Well, what if you are in a position where you need some support that's not about telemedicating you to alter your hormones so that you make somebody else feel better while they're trying to use you for commercial purposes, which unfortunately is what I suspect they do to people involved in high profile judicial proceedings, which may have an undue influence over the quality of the verdicts and the results that the rest of the people of the United States have to work with for pretty much the rest of the livelihood of the United States. But I made footnotes. So I'm going to share the footnotes in case you have a need for the information in these footnotes regarding City of Chicago versus Fulton et al. Okay, so follow up. There's 3 points that came up as part of the reading of the opinion in City of Chicago versus Fulton et al. First of all, is this supposed to be the follow-up to my efforts to contact numerous entities in the City of Chicago and the state of Illinois regarding what I experienced beginning in 2016, trying to go through homeless shelters, homeless and domestic violence shelters? This was issued on January 14th, 2021. That would be 1 month before February 14th of 2016. You know that? 1 month before the anniversary of February 14th of 2016. I was in a shelter processing the estate of a murdered Supreme Court justice at that time. You know that? Does anybody care? It would be 5 years ago. 1 month after this opinion will be the 5th anniversary of that. Do they want me to convey it back to them? Because I'm going to tell you something. What would happen if I did? They can't cover it. With that said, there are other points that are brought up here. First of all, the first point I brought up was considerations of administrative proceedings and the understandings of the potential role of arbitration. There's been a lot of attempt to try to put things into an arbitration process, including an arbitration process that not only will not get the kind of support that one gets when they have an actual formal motion from a court or a judgment order from a judge, but also allows for, I believe, a greater attempt to unduly influence people to allow for a confidentialization of that proceeding or some sort of non-disclose in terms of the terms that can then protect against or prevent against criminal prosecution in the event it is understood that there is an attempt to strong arm or extort people in efforts that would keep them from being completely dispossessed of their own personal private property. And so this is something that's very important, and I think that part of it is what we're dealing with now, specifically when it comes to unemployment insurance, but the unemployment insurance is predicated upon workers' comp. And the hustle that at least has been demonstrated and is evident here in Texas of allowing for smaller civil fees that can be more individually distributed. So it's easier for you as an individual to get access to it, and you can do it in a way you won't even be contested in pursuing, as long as you allow for it to be capped at a certain level and you forego the possibility of using or engaging in any sort of criminal proceeding. And that tears directly to, and I have the book right here, discussing a massive fire that happened at a petrochem facility here in Texas that I suspect is actually an intentionally orchestrated event aimed at a long-term kickback scheme that was attempted for leveraging in order to try to cover up for an intentional effort for members of the Texas gas and oil sector to default and use strategically timed stock dumps in order to offset toxic assets and find and get them covered through alleged health care as they transitioned into a greater derivative economy or a different kind of derivatives economy using healthcare and specifically the pharmaceutical sector. And so that is a huge conspiracy and no one's even touched that's going on right now. And I believe is something that's been several decades in the making and is actually part of a biological warfare campaign that was planned in the 80s. We haven't gotten anywhere near that. And that's not the kind of thing that would have ever been settled in an administrative proceeding regarding workers' comp, or is it? And not only that, how many administrative proceedings regarding workers' compensation were allowed to be confidentialized or allowed to be put under some sort of non-disclosure agreement? So A, it could be prevented from being used in the accumulation of evidence regarding a conspiracy at that level. And B, allowed to be patented or copyrighted as an actual work product or an actual product by individuals or other contractors or subcontractors with a specific entity of concern, so that they're actually like using people's workplace injuries comparably to the way they've been using other intersections with the healthcare sector, which has actually been part of R&D on long-term outlays in some cases through the federal budget process, but also in various kinds of large-scale corporate and industrial sector entities, including in refusal to diversify assets or reduce their dependency on certain practices associated with the gas and oil refining sector, which go all the way back to those subsidies that were offered through like the late 1970s to the early 1980s, relating to the diversification of the gas and oil sector and a move toward green energy. There were subsidies that were offered by the federal government specific to the gas and oil sector all the way up through the last accounting I saw was in 1985. And my understanding is legislatively those subsidies expired in 1985. But they postponed. They put a stay upon the cessation of the subsidy program because the benchmarks hadn't been met. And whatever happened otherwise, the gas and oil sector wasn't ready in the mid-80s to actually fulfill their obligations when they set up the processes whereby they accepted those subsidies. So in some level, we have been contending with globally a refusal of the gas and oil sector to meet its obligations when it accepted subsidies from the federal government in order to transition to green energy that were supposed to be achieved by 1985. And who's been paying for that? Is that something that is about is that something that's been negotiated in administrative proceedings? And until you have what? 40 years of genetically engineering people and orchestrating and contriving matters related to monetizing or financialization of the healthcare sector so that then they can offset their losses through a derivatives economy that's based on products for alleged healthcare service. We're not supposed to hold them accountable for intentionally defaulting on obligations they took on with us as the people via their relationship through the federal government. I mean, that's one question. That's one of the points in this footnote. That would be footnote 1. Footnote 2 was recently an executive order that was implemented by Donald Trump. Now, with this whole impeachment process, there really doesn't seem to have been much attention paid to that. But as I demonstrated, or as I saw, that the day before what would have been Vice President Pence's acknowledgement of the Electoral College vote, there was a number of pieces of legislation the President of the United States signed. I've reviewed a few of them. I haven't reviewed all of them comprehensively, but a number of them. And then a week after that, there is an executive order concerning bankruptcy. Now, I've intentionally thus far not read the President's executive order on bankruptcy. I will now. But nowhere in this concurring or dissenting opinion is there any acknowledgement of the role of the executive office in determinations regarding bankruptcy policy. And I think that that is a big deficiency. I will say deficiency in that. This would have been an appropriate time and an appropriate filing to at least put on the record some judicial consideration of the role of an executive agency in determining the very important issues that have already been brought up, both with what they said and then in consideration of what others, like for instance me, that would be reading it, would say concerning executive authority in making decisions about issues specifically concerning possession, as is discussed here, but also other elements of the bankruptcy process overall. There's nothing in here about that. And it was absolutely needed. That's footnote 2. Footnote 3 has to do with the bill that was pending in 2019 regarding the carbon trust. That there was a bill that I have a post on somewhere else regarding the carbon trust that had been proposed. And there were two things about that bill that were alarming, and I made a public acknowledgement about this at the time. Before I get to those two things, let me just put it into context. This bill was proposed at a time when the state legislature of, I believe, the state of Washington, that members of the state legislature left the state, that there was a cap and trade bill that was being proposed, that was being considered in the legislature, that the governor had taken a stance on it, and that members of the legislature, elected members of the legislature, were so opposed to what was going on regarding the consideration of this bill that they left the state. It was a protest of the legislature that involved them refusing to come on site to the Capitol and actually leaving the state. And around the time this was happening, Congress proposed a bill regarding a carbon trust. And in that carbon trust were two things that were of significant concern. One was that there was a recommendation that what they were going to do is they were going to have another process for considering emission standards separate from the Clean Air Act. But it was going to be meted out over the course of 10 years, concurrent to using the standards meted out in the Clean Air Act. And then after 10 years, if they liked the alternative standard better, then they were going to go ahead and move forward with that. And my concern was, are you going to let people know this is what you're doing? Are you going to let people know that you've got two concurrent standards whereby you are effectuating an analysis of emission standards, and only one of them has been discussed with the public and put into effect as an independent legislation, a bill of legislation that gives people an understanding of what the standard is you're working with. Because in that bill, there was no explication of what the standard was. It was as if there was going to be a secret 10-year period during which they were going to consider emission standards. And if they liked it better, then they were going to switch to that. And if they didn't, would there be any record of what they were doing? And not only that, what were they going to use that for? If you're using a process, are they going to make an index? Are they going to make a 10-year index based on an alternative standard and not tell anybody about it? That was my concern. And then the second concern I had about that proposed piece of legislation had to do with vehicles. Specifically, cross-border transportation involving military vehicles were going to receive a specific and special tax exemption. Well, what constitutes a military vehicle when it comes to cross-border transportation? And that's exactly the kinds of considerations that I'm concerned about in this particular opinion.